CA versus HA, 5578 of 2022, and that judgment landed on the 30th of January 2024. Those who are following along in the case law bundle, the judgment is at page 1. Those who are on page 13, my apologies. On the summary page, you can find this at page 7. So you'll see on the screen, give you the basic case name and a notable quote. I'm going to go through a little bit more details from our case law summary in order for you to understand the case a little bit better. Now, please understand, folks, this is 288 to be exact pages of case law. I'm trying to condense it for you into no more than an hour and a half, and preferably an hour and a little bit session. I know we are all very busy. That being said, it is impossible for me to fly through these judgments and to give you a full rundown of exactly what happened in each case and all the nuance. Some nuance is going to be lost, but hopefully this will be a good way for you to fast track yourself into reading the case and to understanding the case and knowing where to go and look for certain things. So CA versus HA, Western Cape High Court, Cape Town. Judgment was penned by Inziweni J on 6 February 2024, and this matter deals with Rule 43 interim maintenance and spousal maintenance. So this was a marriage of long duration. The parties were married on 1 July 95, marriage out of community of property with the accrual system, and divorce proceedings were instituted as far back as 17 May of 2022. The applicant approached the Rule 43 court for a Rule 43 order where they wanted several orders in terms of maintenance for themselves. What this judgment deals with is disclosure in Rule 43 matters, and the principle that Rule 43s require full, honest, frank, clear disclosure of financial affairs, the principle of clean hands. And essentially what happened in this matter is the application was struck from the roll due to applicant's failure to fully and honestly disclose all the material facts regarding her financial situation. Each party was ordered to pay its own costs, so the applicant was not mulcted with costs. However, it is very, very interesting to see the stance that is being taken by the Western Cape High Court regarding disclosure and non-disclosure, shall we say disclosure or lack thereof, in Rule 43 matters, particularly in light of the judgment by Kluter J in October last year regarding Rule 30 and prolixity in affidavits, etc. I know many of our friends and colleagues in the Cape are lobbying very, very hard for the introduction of financial disclosure affidavits and financial disclosure forms as we have them up in Gauteng at the moment, which I think will certainly be of much assistance to judges and to litigants in Rule 43 matters. So we are all holding thumbs that you will get your FDFs soon, Cape Town colleagues. A very interesting quote from the judgment on paragraph 18. As mentioned earlier, the principle of disclosure is of utmost importance in any Rule 43 applications. Likewise, in a Rule 43 application, it is expected of an applicant to demonstrate a measure of candor and diligence in disclosure of his or her personal circumstances. An applicant cannot simply elect to place before a court only those facts which are going to be favorable to his or her case and withhold those that are detrimental to the case. To that end, it is expected of an applicant to disclose full facts in the founding affidavit which might have an influence on the court's decision. It takes us all the way back to the principles of Dupree versus Dupree. You have to approach the court uberime fidei, tell the court what is going on, and if you do not do so, you run the risk of not getting relief in terms of Rule 43. So very, very interesting matter, CA versus HA, all the way from the Western Cape, Rule 43, interim maintenance, and a matter removed or struck at least from the roll due to non-disclosure by the applicant. Very interesting that the matter was not dismissed. One would then surmise that the applicant would have an opportunity to do a Rule 43(5) affidavit to place all financial information before court, but obviously they cannot simply do that just as of right. So very, very interesting Rule 43 judgment in a line of very interesting Rule 43 judgments from the Western Cape High Court in respect of Rule 43.